What rights do you have in the digital environment in the European Union? Hello and welcome back to TEPSA Explainers. My name is Susana de la Sierra. I am Associate Professor at the University of Castilla-La Mancha in Toledo, Spain, where I teach administrative law in the law degree and public policies in international studies. In today's video, I am going to talk about digital rights or citizens' rights in the digital environment. I would like you to take with you, when we finish the video, what rights do you have? I would like you to explore them and to use them if necessary. Digital transformation is a fact. It is a process that has been ongoing for several years now. We all shop, work, study online. We interact with other people in social networks. We interact with public administrations, with other institutions, and with private companies in digital environments through digital means. This has, of course, many advantages in terms of efficiency, speediness, but there are some risks and some challenges. If our whole life turns digital, then what happens with those people who do not have access to the digital environment? Because maybe they don't have the means, they don't have a computer, they don't have access to the network, or they don't have digital competencies, digital literacy. Because this may pose problems, for instance, for equality, for the equality principle, some states and the European Union have promoted in the last years the adoption of various documents on digital rights, charters and bills of rights. This is the case, for instance, outside the EU of Brazil in 2014, where an act on rights related to the internet was adopted. Also in 2015, the Italian Parliament adopted a declaration on rights related to the internet. In France, in 2016, the Digital Republic Act was adopted, and in 2021, both Portugal and Spain adopted charters of digital rights. These are documents, some of them are norms in the strict sense. They have binding nature, legally binding nature. In other cases, they are public policy documents. As for the European Union, the European Commission proposed last January, it proposed to the Parliament and to the Council to adopt a declaration on digital rights and principles. It is again a public policy document. Many questions arise in these frameworks. For instance, what happens if an algorithm is used to take a decision to impose a fine, for instance, to a citizen, or if it's used in order to determine a diagnosis of an illness? Can we contest that decision, and how? For instance, can we monitor freedom of expression, freedom of speech in social networks? This is a very debated and a very debatable issue. If yes, if we say we can monitor it, who is going to monitor it? Is it going to be a judge, an administrative authority, or a private company? Well, I am not going to give you the answers. I just wanted to underline the importance of these instruments and to make you aware of them. My recommendations could be, in the first place, these should be real norms, hard law norms. In the second place, public debate should be promoted on this, which is already the case. And in the third place, public awareness should be done as well in schools, and digital competencies should be promoted. So thanks for watching, stay tuned, and please make sure to like and follow us, and see you in the next TEPSA Explainer.